Good day, Crime Talk aficionados. This is Scott Reisch. Today we're going to talk about the Tiffany Moss homicide case in Atlanta, Georgia, where she is representing herself accused of starving to death her then 10-year-old child, and the verdict is in. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch. If you like the channel, please subscribe. If you like our video, please hit that like button, and please hit that little bell if you would like to receive notification of new videos coming out or when we are going to go live. Today, Tiffany Moss, the woman in Atlanta, Georgia, who is on trial for the murder of her stepdaughter, Emani Moss, has been found guilty of all counts of murder, felony murder, cruelty to children, and trying to conceal Emani's death by burning her body. This case is interesting in several respects. Obviously, it never ceases to amaze me, the terrible things that people will do in this world, let alone the terrible things that people will do to children. And in this particular case, it wasn't a whodunit. Eman Moss, the father of Emani, confessed. He told the police what he and Tiffany had done to their daughter and how they tried to hide her disappearance. He took a deal of life without parole to avoid a death sentence, and Tiffany Moss was given the same offer, and she rejected that offer and decided to proceed pro se, which means to represent herself. And I'm sure a lot of you have heard the famous quote that he who represents himself has a fool for a client. Miss Moss, although she has a constitutional right to represent herself like anybody, this is not the case that you want to do it in. If you want to go represent yourself in a traffic ticket, go for it. If you want to represent yourself in a traffic violation, go for it. But when you're charged with a misdemeanor, a felony, let alone a capital homicide case, you do not represent yourself. The first thing any judge would do or their counsel would do is to see if this person is in fact competent. Do they understand what's going on in the courtroom here today? Now, when somebody wants to represent themselves, the judge will usually give them an advisement. And in that advisement, it'll say the area of criminal law is a highly complex area of law, and it requires special skill and training. There are people that do just criminal defense work. On top of that, you have to know criminal law. You have to know the rules of criminal procedure. And then on top of that, you're supposed to know the rules of evidence. The judge cannot give you any benefits or favoritism or help you in any way. We've talked about this. A judge should be up there calling balls and strikes. And if you want to be silly enough to represent yourself, particularly in a death penalty capital murder case, the judge can't help you out. He cannot make objections for you. The prosecutor is going to walk all over you. Now, hopefully, and in this particular case, it sounds like the prosecutor has a duty to make sure the record is clean, to make sure there's not anything that's going to be reversible error. In this particular case, Miss Tiffany Moss, the mother, the one who's on trial for this capital offense, she represented herself. She asked very few questions in voir dire, which was the selection of the jury. She presented no opening statement. She did not cross-examine any witnesses whatsoever, and she did not present a closing argument. Now, certainly the government always has the burden of proof, and that burden never shifts to the defense to prove themselves innocent in any way. But this is the type of case where throughout the trial, even if it is a long, basically guilty plea, you still want to get in those mitigating factors, that mitigating evidence in the case, so that the jury can start thinking about it. Yes, we're going to find her guilty. It's not a whodunit, but wow, this really weighs into the circumstances that would reduce the chances of a death sentence in this case. Now, Miss Moss had two very experienced capital death penalty defense attorneys who at one point just recently filed a motion to intervene on the case and say, let us do this case. She is not doing herself any favors. And the judge rejected their request to do so because although Ms. Moss should have had counsel ready, willing, and able to defend her, to do everything they can to make a record so that there's going to be an appeal if there in fact is a death sentence in this case, all those issues are now waived and gone because she didn't preserve them by objecting. And that's the tragedy of this case, in the sense that if you do not object to something that is objectionable, that something is basically reversible error, if you do not object, that issue is waived on appeal. You cannot raise it unless the judge should have done it. It was what they refer to as plain error, where basically the prosecutor shouldn't have allowed it, the judge shouldn't have allowed it, should have stopped it, what they call sua sponte, on their own, but they didn't. In this particular case, Ms. Moss did not receive any of that benefit. And so she's going to pay the benefit, or she's going to pay for this, and possibly with her life. So let's get into some of the facts of this particular case. The cause of death was starvation, all right? And I've talked about this briefly, still can't talk about it in a great deal, but I have done starvation cases. These are not easy cases. Let's talk about the facts of this particular case. Tiffany Moss and Eman Moss were charged with murder, felony murder, cruelty to children, and concealing Emani's death. Eman Moss, the father, confessed to the police in exchange for his testimony against Tiffany. He took a life without parole sentence in exchange for taking the death penalty off the table. Tiffany Moss was given that exact same offer and rejected that, stating that she was going to leave it in God's hands, or God's will. She then, throughout this case, had counsel early on, but ultimately dismissed her counsel. And this is not the type of case where you don't want to have an attorney. So, what led up to all this? As we understand it, Tiffany Moss pled guilty in 2010 to abusing Emani Moss, and she was sentenced to probation, as most people would get, unless the child is severely injured. And as a result of that plea, though, a child abuse, Tiffany Moss was no longer able to teach school in a preschool environment where she was employed. Tiffany Moss blamed Emani for this, and she also blamed the state. What we know is that Tiffany Moss and Eman Moss, the father, starved this young girl, Emani. She ultimately died, and when they believed that they had found her, she weighed roughly about 32 pounds. Okay, she's 10 years old, obviously a little underweight. But what they tried to do was they tried to stuff her into a bag and try to burn her in an apartment complex. The body was ultimately found. The stepmother, Tiffany, and the father, Eman, tried to call the police and say that the plan was that she was going to run away, and they have no idea where she went. Like I said, the father completely confessed in exchange for his guilty plea. The father was not even cross-examined in any way by Tiffany Moss at the trial, and no evidence was presented whatsoever on her behalf. So the verdict came back guilty to all counts, which was not much of a surprise in this particular case. It wasn't a whodunit. But now they go to the sentencing phase. And the sentencing phase requires the prosecutors to prove what are under Georgia law as aggravating circumstances. And those aggravating circumstances have to exist for the capital punishment part of the case. In Moss's case, the jury will be asked whether the crime was so outrageously or wantonly vile, horrible or inhumane, and that it involved torture, depravity of mind, or an aggravated battery to the victim. All right? And if the jury makes that finding, the prosecution can then present additional evidence in favor of the death sentence. So this particular case really has three parts to it. One, the factual basis. Did she commit murder, as well as the other charges? And the jury said she has. If the jury finds that there are aggravating circumstances, then a third phase would begin where they would present evidence related to more information about Tiffany Moss, how Emani passed away, how she would have died, how the body would have shut down. These are all things that the jury's already heard, but they go into a little more detail about it. And the jury in this particular case has already become very emotional. In fact, the jurors were more emotional about Emani's death than the stepmother or even father in this particular case. The jurors at least shed some tears for this child. And these jurors have a huge responsibility, because it's one thing to say, oh, yes, somebody commits a crime, they should receive the death penalty. It's another thing to actually be the juror, to sit there and say, yes, you are going to die, and I am going to be responsible for that. Now, the juror can say, well, they're the defendant is the one that created the facts, but they have to live with that. And a lot of people can't do that, even though the jury is what they say is, as the jury is qualified as a death jury. And all that means is that the potential juror has to admit that they are able to, if the facts and circumstances present, impose the death penalty. If one is absolutely opposed to the death penalty, they could never sit on a death-qualified jury. So over the next several days, maybe it won't take long at all, the jury will come back with a decision as to whether those aggravating circumstances exist and whether Emani Moss should receive the death penalty. If those circumstances would take place, Miss Emani Moss would be only the third woman to face execution in Georgia. Doesn't happen very often, and this particular case, when you look at the pictures of her when you're walking down the street, is this what a murderer looks like? I don't know. What does a murderer, child abuser look like? You never, ever know. So the Tiffany Moss case is unique in that you have a defendant in a death penalty case who wants to represent themselves. That doesn't happen very often, because when somebody is actually accused of murder, they usually want to get the best representation that they can. This particular case, one would believe, or at least it's my opinion, and I'm telling you it's my opinion, that Miss Moss has basically given up. And for whatever reason, she may have her own death wish. But she turned down, against everyone's advice, the option of having two qualified death penalty attorneys to represent her. A lot of people have always thought that you could have an attorney represent you if you're accused of a crime. And yes, you are entitled to have an attorney under the Sixth Amendment to the United States Constitution. However, what most people don't realize is that to actually have an attorney appointed for you if you cannot afford one was not a right, or was not determined to be one, until Gideon v. Wainwright, which was a case decided in 1963 by the Supreme Court. And in that case, it was a unanimous decision. The Supreme Court established that the 14th Amendment creates a right for a criminal defendant who cannot pay for their own lawyer to have one at state expense. Okay? Basically, it created a public defender's office. And at that point, if the state could not, or the public defender's office had a conflict, then another private counsel would have to do the representation. Now, courts would appoint attorneys to represent people in serious cases if they wanted to do that. It wasn't good pay. It wasn't glamorous pay. And if anyone's ever seen To Kill a Mockingbird with Gregory Peck, the movie, based upon the book, that was probably the movie that made me think, oh, I want to be a defense attorney. I want to be, the guy representing the little guy in there, the guy that is innocent and is getting railroaded through the system, as it happened in that particular movie. And although it was fiction, we all know it was probably more truth than fiction in any way. So, just a quick recap. In Gideon v. Wainwright, Mr. Wainwright, Gideon. In Gideon v. Wainwright, Gideon was charged down in Florida with a non-capital felony, and he appeared without funds and couldn't afford for counsel. He asked the court to appoint him counsel, but the court denied on the grounds that the state law permitted appointment of counsel for indigent defendants only in capital cases, all right, murder cases. And Gideon conducted his own defense, as well as could be expected for a layman not being familiar with criminal law, criminal defense, and criminal procedure, but was ultimately convicted and sentenced to a term of imprisonment. Subsequently, after conviction, Gideon applied to the Florida State Supreme Court saying that he was entitled to counsel and he was denied all relief. He ultimately appealed to the United States Supreme Court, filing his own writ of certiorari by hand. The United States Supreme Court said, or held in Gideon v. Wainwright, that an indigent defendant, somebody that has no money, in a criminal trial has a constitutional fundamental right to assistance of counsel so that they can receive a fair trial. And if he does not receive that counsel, that the 14th Amendment is violated and someone is not going to receive a fair trial. Now, a lot of people think, oh, no one should get a public defender. No one should get court-appointed assistance of counsel. Most people cannot afford an attorney on their own when they're charged. Yes, we have lots of private counsel cases. Yes, we still take court-appointed cases. But if you are charged with a serious felony or you are charged in federal court, most people are not going to be able to come up with $50,000, $100,000, hundreds of thousands of dollars to properly represent yourself. Paying for attorneys, paying for experts, those things are expensive. And we want a fair trial process in our system of courts here in the United States because that is the right thing to do. Leave your comments about the Tiffany Moss case. Let me know. Do you think that you could sit as a juror, be fair and impartial, and ultimately impose the death penalty? Do you think that she should get it? Let me know. Leave a comment below. Thanks for watching. Please hit the subscribe button if you like our channel. Please hit the like button if you like the video. Leave a comment and hit that little bell so that you're notified of future content and when we go live. Thanks for watching Crime Talk.